actions.
I want to be clear, Ms. Blatt. In this case, we don't have a question, although the Sixth Circuit acknowledged it, about whether the reasonable time period should only start when enforcement is attempted, correct?
Correct.
And because that seemed to be a part of your opposing counsel's opening argument, that somehow it was reasonable because...
Yes, and I mean, we think the question presented forecloses that, but we do think that at the time of enforcement, it could be quite reasonable to wait. Here, though,
but you do agree, there are many, many judgments entered, some with or without notice, but somebody might find out about something, no one's ever tried to enforce it, and why spend the money getting a lawyer? We don't want to encourage.
Right, that's what I was saying. I think it might quite be reasonable to wait until the time of enforcement. That might be the first time the person's ever heard of it. The person might have reason to think the judgment was never going to be collected. And most importantly, there may be no prejudice from whenever the movement filed. So we would just think a district court would have wide discretion. I would say that this case is kind of the poster child of why you can't really say enforcement, because it's conceded in 2016 that the trustee was trying to enforce the debt and then spent 7 separate attempts and thousands of dollars to get to the point of seizing the bank asset.
But that's an issue that a court below will have to address in another
No,
case.
because they've all conceded that it's reasonable. But yes, in any given case, prejudice would be considered. I think Justice Jackson made a very good point. The debtor, Vista Pro, filed the allegedly improper service. The trustee comes in, sees a valid judgment on its face, has no reason to think there's improper service, doesn't even find out that there's an alleged improper service until 5.5 years after the fact, when it's way too late. Had the judgment debtor just said at year 1, hey, there's improper service, they could have redone the service. So these are the kinds of arguments that would be considered had the other side tried to offer a justification. But I do think Justice Jackson makes that good point that there might be prejudice if the person has no reason to think the judgment's invalid and has, claiming please pay in a bankruptcy estate, just wasting money trying to go after a judgment debtor that should go to creditors.
Ms. Blatt,